This is a truncated version of my talk about the additional paternity leave regulations which come into force April 2011. Currently, fathers get 2 weeks of ordinary paternity leave and mothers a year's maternity leave. The new entitlement is going to be divided between both parents, which ostensibly is supposed to give a better opportunity for fathers to be involved in childcare. From the 3rd of April 2011, fathers are entitled to ordinary paternity leave taken in 1 or 2 week blocks of 1 week, and it has to be taken up to the 56th day after the child's born. They're entitled to statutory paternity leave, and they're entitled to statutory paternity pay during that 1 or 2 week period. Further, there will be entitlement to additional paternity leave. That's up to 26 weeks, which is to be taken before the child's first birthday, and additional statutory paternity pay, which is payable for the remainder of any period of statutory maternity pay which hasn't been exhausted by the mother. In order to be eligible for the leave, it has to be either the father or partner of the mother, and there is a specific definition of partner. It doesn't have to be the husband, it could be somebody who lives in an enduring family relationship with the mother, but not an immediate relative of the mother. The mother has to be entitled to maternity leave, SMP, or maternity allowance. The father should have 26 weeks of service at the 15th week before the expected week of childbirth, and the father should still be employed at the start of additional paternity leave. The leave should be taken by the father to care for the child, and the mother should have already returned to work before the father is able to go and take paternity leave. Additional paternity leave, the minimum amount of time that can be taken is 2 weeks and the maximum is 26 weeks. The earliest that the father can start it is 20 weeks after the child is born, or if it's a case of adoption, 20 weeks after the child is placed. And the father has to finish taking the additional paternity leave before the child is 1 year of age, unless that child's mother dies, in which case there are specific dispensations which apply. In order to take the leave, the father has to give his employer particular notice. Notice has to be 8 weeks prior to going on leave, and the notice should state the expected week of childbirth, the date of the child's actual birth, when additional paternity leave is intended to start and finish. The father has to declare that he is the father, or as it may be, partner of the mother, that he has main responsibility, apart from the mother, of the child's upbringing. And the mother also has to make a declaration on that form with her name and address, her return to work date, whether she's in receipt of either statutory maternity pay or maternity allowance, her national insurance number, and also declare that the father or partner satisfies the eligibility criteria and is the only person claiming additional paternity leave in respect of that child. It is advisable that employers also seek consent from the mother to processing her personal data, given that the declaration form will have a significant amount of information on it. And it will be noted that the declaration forms are a form of self-certification, as the impact assessment prior to these regulations coming into force suggested that there would be a low level of fraud, and that this would be the most sort of admin-free manner of administering this new entitlement. But if there is a concern in relation to further verification, a way to attempt preventing fraudulent applications is envisaged in the regulations. So within 28 days of receiving notice, an employer can ask for the birth certificate and details of the mother's employer, and the employee is obliged to provide that further information within 28 days of the request. However, once you as an employer have the details of the mother's employer, and you even request that that the mother's employer reiterates or confirms the information that you have received, there is actually no obligation on the mother's employer to actually respond to that query. And in fact, the mother's employer might be worried about the data protection of their employee and be quite reluctant to give it to a third party for whom they have no obligations towards. The additional paternity leave regulations also come with additional statutory paternity pay. To be eligible for that, the father must qualify for additional paternity leave. He must qualify for statutory paternity pay, i.e. have 26 weeks of continuous service at the 15th week before the expected week of childbirth, and meet the lower earnings limit. The mother must have already returned to work and not used her full 39-week statutory maternity pay period or maternity allowance as applies. And the pay payable is the same as statutory maternity pay, so that's the lesser of the statutory paternity pay rate, which as from the 1st of April will be £128.73, and 90% of the actual pay. So whatever is the lesser, that's what the employer will be entitled to. Now, you may have in your handbooks an enhanced maternity pay, so instead of 90% of pay for a number of weeks, it might be 100% of pay for a number of weeks or months. Now, as there is a new regime in terms of fathers being entitled to additional paternity leave, the question arises whether enhanced paternity pay should also be offered to those fathers. Now, there's no express entitlement in the legislation, and under the Equality Act 2010 there is an express permission for the special treatment of women in connection with pregnancy or childbirth. However, it's not clear that employers are able to rely on that, as recent European case law, for example, it came out of Spain recently, a case where in Spain they have the right for mothers to leave work in order to either breast or bottle feed their children, and a father wanted to take this leave in order to bottle feed his child and was refused. It went to court, and the European Court of Justice said that it was related to parenting and family time rather than pregnancy or childbirth, and so the same could be said for additional paternity leave, given that it has to be taken 20 weeks after the child is born. And a way to reduce the risk of any such sex discrimination claim would be, I guess, levelling up or down any enhanced maternity pay, and also consider restructuring any return to work bonuses that you might have which apply just to women on maternity leave at the moment. In relation to rights during additional paternity leave, they're pretty much the same as those applying to women on additional maternity leave. So all of their employment terms, save for remuneration, so they get their normal benefits, kit and reasonable contact days apply, and the enhanced position of employees at risk of redundancy when on leave also applies. A quick note on managing cover: as employers only get 8 weeks notice, it's probably worthwhile asking expectant fathers sooner if they expect to take this leave, and given that the requests might start coming in by the end of June 2011, getting your forms and policies in place now seems to be a good idea, and of course using those kit and reasonable contact days. Fathers can return to work earlier than they've stipulated if they give 6 weeks notice, and employees on additional paternity leave are entitled to return to exactly the same job if they've taken additional paternity leave of no longer than 26 weeks and the mother hasn't taken additional maternity leave of more than 4 weeks. Otherwise, they're entitled to the same job unless it's not reasonably practicable to give them that job, in which case they're entitled to another job that's both suitable and appropriate. Finally, a note on remedies. An employment tribunal declaration that they've been unfairly treated, an award that's deemed just and equitable, or if they're dismissed because they've taken leave or sought to take leave, they would be automatically unfairly dismissed and entitled to compensation up to the cap as applicable at the time. There's also a possible direct or indirect sex discrimination claim, and more likely indirect sex discrimination, i.e. the argument that even if an employer has treated them the same, the refusal to grant paternity leave has a greater impact on men overall.